Ajdler versus the province of Mendoza. Counsel.
Good afternoon, Your Honors. May it please the Court, Michael McGinley from Deckard LLP on behalf of the appellant, Mr. Ajdler. I'm joined by my colleague, David Hoffner. I'd like to reserve 2 minutes.
You may, sir.
The plain terms of the indenture that apply here and this Court's decision in NML Capital allow Mr. Ajdler to recover post-maturity interest within a 4-year limitations period, including on claims after the principal is time-barred.
Forever?
Your Honor, our position is that once he brings his claim, if he prevails on his claim, that then merges the contract into the judgment.
But he could wait till 2060 to bring the claim?
Well, we also think latches would apply in some kind of extreme scenario where he waited multiple decades. But yes, Your Honor, I mean, we think that the plain terms of the contract provide that post-maturity interest is available. This Court's decision, NML Capital, says so. And the Court's decision in NML Capital also points out that in a complex financial document like this, financial instrument, the terms are construed against the bond issuer. And there's very good reasons for that, because they have complete control over the terms that are written into the bond. If Mendoza didn't want post-maturity interest to continue to run past the time of limitation.
But aren't the post-maturity interest payments a conditional remedy, partial contract remedy? It's conditioned on the breach? Isn't that what we've said?
No, I don't think so, Your Honor. I mean, in NML Capital, what the Court said was that there are 2 separate obligations, and that, you know, the fact that one might the limitations period might run doesn't mean that the limitations period on the other runs.
But can't under that case, I mean, it didn't deal with this particular question or this particular situation, and couldn't that more logically be understood to mean that you could sue on the interest before the principal matured, and that was the reason for dividing the 2?
I don't think so, Your Honor, because what NML Capital dealt with post-maturity interest payments, and what the Court says is that the only event that would extinguish the obligation to remit those payments is payment of principal or the merger of the contract into a judgment.
But it was a timely action there, or am I wrong?
It was, but, you know, the logic of the Court's decision is that the only events that can extinguish the right to remit payment is on interest is payment of principal under the plain terms of the contract or merger into a judgment.
But didn't we distinguish between pre-judgment and post-judgment interest? And isn't that where?
There's a distinction between pre-judgment and post-judgment, but there's not a distinction between post-maturity and prematurity. And what the Court says in NML Capital is
I meant post-maturity, excuse me, I said post-judgment. I meant post-maturity.
I don't think the Court drew any relevant distinction in terms of a plaintiff's ability to bring suit on the separate obligation to pay interest.
But if we have basically 2 choices, which with a third issue, I guess, thrown in some ways, but one is we can adopt a rule and say maybe latches, but you could bring this action in 2060. Or we could say you have a hard cap 4-year, in this case, statute of limitations, or 6 in another. You have to bring an action by then, and you can get whatever payments are due at least in that time period up to the time you bring a timely action. Why would we adopt the 2060 rule?
Well, I mean, first of all, I don't think there's any incentive for someone to sandbag and wait for 40 years.
Well, what was the incentive here?
There was no incentive. There's nothing in the complaint that gets to this, but my understanding is just a mere oversight on behalf of my client. That doesn't mean that his right was extinguished, though. In fact, Section 4.7 of the indenture specifically says that any delay in asserting a right doesn't waive that right.
Because we don't take it well when someone tries to extend the statute of limitations, right? That's a policy basis we've used to justify certain decisions. So it seems to me this would be perhaps the ultimate extension.
With all respect, I would disagree, because we're not seeking to extend the statute of limitations, or here the prescription period, on the principal. We admit that principal is time-barred at this point. We also admit that we would only be able to look back for 4 years. So at any point, the window would only be a floating 4-year window, which is not that extreme of a scenario. And, you know, we should keep in mind the reason why we're here
Well,
is
it would
because...
be back 4 years and into the future in perpetuity, no?
No, because our position is that at any point that we enforce our rights through a lawsuit, if we prevail, that extinguishes the claim that merges into a judgment, and so we can't bring further claims on
The time
interest.
for you to make that first enforcement action, there's no limit on that under your rule, other than, as you say, latches, which I'm not sure I understand how you get latches in a legal action for breach of contract damages.
I mean, I think there would be practical limitations because, most holders their incentive would be to bring it sooner, and I don't see there being any...
But the problem is that there's really no way to draw a line. So what you're relying on, as I see it, is, assuming that most people won't want to wait that long, but, can we have a rule based on that assumption?
I mean, Your Honor, I think the rule is dictated by the plain terms of the indenture. I mean, that's what the court says in NML Capital. We're here because their indenture provided that they would pay interest until payment of principal. And the ultimate reason we're here is that they voluntarily decided to stop fulfilling their obligations under the indenture. So I think their claim that somehow they're going to be victimized by this perpetual accrual of claims rings hollow because they could pay principal at any point.
But, there's a public policy to have closure and to not have these stale claims, and your argument really is about decades, if not generations into the future. But help me here. This section 4.6 of the indenture that says, notwithstanding any other provision of this indenture, bondholder has a right to receive payment of the principal and interest on the stated maturity. Why doesn't that mean that it's all from the maturity, and it's 4 years from there, and that's as far as you can go out?
Sure, and of course, that's my friend on the other side's argument. What we would say is that 4.6, by and large, what that does is it says no longer is it the trustee that would bring the suit, the bondholder has a right at that point. The bondholder can sue for principal and interest that had accrued up to that point, so we're talking about prematurity interest there. The argument that the other side makes that somehow that then extinguishes post-maturity interest claims or accelerates their prescription period is inconsistent with Section 15, the prescription period.
Yeah, but I don't understand how you get around the beginning of 4.6, notwithstanding any other provision. Meaning, this is the provision that binds, and this is the one that says a bondholder has the right to sue for payment and interest as of the maturity date.
So two ways I would say
Yes.
that doesn't mean what the other side says.
Okay.
One is that notwithstanding other provision is clearly talking about 4.1 through 4.5, which talk about the trustee's ability to sue.
Yeah,
And
except it doesn't say that. It says notwithstanding any other provision in this indenture, which means the entire document.
Sure, and then what I'd say is the next provision, 4.7, says that no right or remedy conferred in the indenture is meant to exclude any other right or remedy, and that they're cumulative. And
So I want to take a step back and have a more basic understanding of what you're arguing the post-maturity interest is. If it's not a contractual remedy, is it consideration for the indenture, like the maturity interest?
We do believe that it's a contractual remedy. We brought a breach of contract action.
Okay, so just, if that's the case, how can you just pursue that, with an unlimited time duration? I just...
Of course, we don't argue that.
We've never... That just seems to be so against the public policy of the state.
I don't think so, Your Honor. And just to be clear, we don't think you could bring it forever. We've proposed two limiting principles. But it also is fully consistent with what the court said in NML Capital, which is that when you have separate obligations, one to pay interest until principal is paid and one to pay principal, that those accrue separately, and that the interest payments continue to accrue even after.
Isn't that the ultimate question? It's almost an epistemological question about what we know and when we know it, I guess, because the question here is can interest exist without principal? And to accept your argument, we have to accept that principal has no relevance. The statute of limitations is run on principal, but it can still continue to run on interest. And isn't that contrary to 400 years of common law that said interest follows principal?
So with respect, I would disagree that that's exactly what we're saying. The first point that I would make, and I'm getting questions here. I want to make sure that I have reserved some time for rebuttal. Is that okay?
Of course you have,
Okay.
yes.
The first point that I would make is that the limitations period doesn't extinguish the underlying right. What it functions as is a bar to the remedy, and therefore it can be waived. If we were to, if when we brought this
Yes,
suit,
that'd be great. If interest and principal were two separate things, it requires you to do that, and you argue that in the indenture that they are two separate things.
that's correct.
That's right, and NML Capital says that. How do you reconcile, you're familiar with Chapin?
I am.
Okay.
And I'd love to talk to you about that. So in Chapin, it was a very different contract. In Chapin, the installment payments were for principal and interest together, like a normal mortgage interest, and the claimant in that case brought a foreclosure action.
Right.
Right? In Union Trust, by contrast, which is what New York jurisprudence relies on, it was clear that they were separate obligations.
Well, Williston doesn't, though, do they?
No, but the case that Williston relies on actually says that in some circumstances, interest payments can accrue separate from
But you'll acknowledge that Williston goes the other way on that.
I would acknowledge that the text of Williston says something different. The points I would make are that New York jurisprudence is about New York jurisprudence, whereas Williston's making a basic claim about the common law. And I would say that the case that Williston relies on actually supports our argument because it says that in some circumstances, if it's clear that interest payments are separate and apart from principal payment, they can function that way. It's also what the Second Department said in Amruzi only 2 years ago, applying this court's reasoning in NML.
You were on
Capital.
Chapin, though. I don't want to get you too far off that, because I think that's a key case for you to address.
Yeah, and again, in Chapin, the difference is you had the payments, the installment payments that were due were principal and interest together, right? And I think that that's why it was more in line with the traditional cases which treat interest as a mere shadow or an incident of principal. But once courts were confronted with scenarios like this one where you have separate obligations, the parties clearly treated as separate obligations, they said that the terms of the contract have to govern, and that the two function differently. And that's why you see Union Trust and Amruzi reaching a different result than Chapin.
But they deal specifically with this mortgage interest, some call it mortgage interest exception.
Yeah.
This isn't a mortgage here, so I mean, and there were a whole bunch of other circumstances surrounding
Sure.
Union Trust and the cases that followed that, that
Yeah.
aren't applicable here.
So in Union Trust, it only talked about the moratorium statute as an alternative holding. The core of the holding was that they were separate obligations and they had to be treated as such. Amruzi is clearly not a moratorium case. It's from 2017.
They are mortgage cases.
It's a mortgage case, but it's on a note, right? And it also was not a foreclosure action. It was not on payments that were principal and interest together. It was on separate interest payments that under the note said continued to accrue until payment of principal, which is identical to the language here. And so I think if you look at those cases together and you look at this court's decision in NML Capital, it's clear that the party's contract has to control, particularly in a sophisticated financial instrument that the
Well, when
bond
they
issuer.
entered the contract, NML had not yet been decided.
Sure, but when Argentina entered its contract, NML had not yet been decided.
Thank you, counsel.
Thank you.
Counsel?
Thank you, Your Honor. May it please the Court. Carmine Bacuzzi from Cleary Gottlieb on behalf of the respondent, the province of Mendoza. The certified question should be answered no. Plaintiff had the right to sue at maturity for its principal and all interest due and owing until principal was paid or merged into a judgment. That is what 4.6 provides, as well as the promise relied on by my friend that interest is owed until principal is paid. That is, in fact, how the plaintiff pleaded their claim. If you look at the complaint, which begins at A4 in the appendix, it specifically starts in paragraph 1 saying this is a claim for principal together with all accrued and owing interest. It then goes on to cite repeatedly and at length section 4.6, and then in the one cause of action, there are 4 causes of action in the complaint. 3 of them are based on the so-called pari passu clause, which is not an issue here. There's one claim for damages, the first cause of action, and that is for principal and interest. And they state in paragraph 62, as well as the prayer for relief, that they are entitled to an amount to be determined at trial, but not less than an amount equal to the principal of plaintiff's bond, together with all accrued and unpaid interest due pursuant to the terms of the bonds.
Is there a distinction between prematurity and post-maturity interest? For example, that prematurity interest would be considered consideration and post-maturity interest might be considered remedial? And if you agree with that, how does that factor into the issue here?
You could think about that in that way. And so the idea of post-maturity interest as remedial even more puts it in line with the case law that we cite, going back decades and decades in New York jurisprudence, that it falls with the principal. But the other way to think about it is to think about what is the moment of accrual? How do you get to claim this principal, this interest, excuse me. And it's clear from the document, and this is also in NML, Your Honors. In NML did in a timely manner what these folks want to do in an untimely manner, which is NML came right after maturity or acceleration, and they said what we get is the principal, we get all interest, whether it was pre-maturity and not paid or post-maturity, and we get that through merger into judgment. And that is how this court characterized the claim, and they get interest on top of that interest at the statutory rate under the CPLR 5001. And so if we follow the cases from this court, the Vigilant case in 1995, the Hahn Auto Warehousing case, we cited also the Knapp case from the First Department in 1894. When the facts on the ground are such that you can make your claim, then you've got to do it because the statute has started to run. And so that is what NML did, and it was specifically stated in the ability to get principal plus all interest going into the future.
What's your response to his point about section 4.7, that all the rights are cumulative?
All that.
I read 4.6 as you suggest it should be read.
I'm sorry?
I read 4.6 as you suggest it should be read, but he says, oh, Judge, you've forgotten about 4.7 that says all these rights are cumulative. What's your response to that?
4.7 further proves the point, because that means to the extent there are rights reserved for the trustee in 4.1, and if you look at section 4.1b, it is, I believe, where it talks about if there's a non-payment of principal, it states explicitly the trustee then can go in on behalf of 25% of the principal holders and demand all principal with all interest owed, the whole amount. So it's not this everything is divergent and interest floats out here separate and apart from the concept of principal. That ties it together. And he had the right to avail himself of that because, as pled in the complaint in paragraph 29, since there was such an overwhelming acceptance of the exchange offer that the province of Mendoza did because of its financial straits, by the time we were in 2004, 2005, he had over 25% of the outstanding principal because his client or his predecessor in interest was the last person who didn't take the deal. And so they could have had the trustee bring this remedy, or pursuant to 4.6, which says ignore 4.5, which has limitations what you can do. If you are owed principal and interest bondholder, you can do it. Absolute and unconditional rights. Those are the words in 4.6. He had that right to do it. It started, therefore, to run under the contract at 4 years. If we were in the statutory context, it would be 6 years. And his contrary rule, Your Honors, is unworkable. He is saying, I would like to have 4 years of interest, the 4 years of interest that accrued by the happenstance of when I decided to bring my complaint. So here between 2013 and 2017.
So what is the actual rule you're proposing?
The actual rule we're proposing is to apply the vigilance standard and say when you had the right, the ability to assert a claim, whether for principal or interest, the statute of limitations begins to run. And so if you have not brought that claim within the 4 years, then you are time barred.
Counsel, if we answer the first question, no, do we need to reach the question footnote 6 of the circuit opinion?
No, you don't, Your Honor. You don't.
And that's because the statute would already have run anyway on those, let's call them the interim interest payments in
Correct.
the 4-year period?
Correct. And the issue in footnote 6 is academic here, because if they wanted to take advantage of the so-called mortgage rule, they would have had to have sued no later than 2015. Since they came into 2017, even importing that rule into this context, which I would say the court should not do, wouldn't help them. So it's very academic for purposes of this
So
appeal.
you're asking us to look at this case as an accrual case, not as an enforcement case.
I see them going hand in hand, but if that distinction is helpful to Your Honor, then I accept it. The point is, when do you look at when the claim accrues? You add the time, and if you've sued after that time, you can enforce the claim, thought about in that way.
So under your rule, you mean as of the maturity date?
Correct, because it's crystal clear at maturity, you can sue, as NML did, you sue for principal, and all interest, where that amount of interest is judged by the standard of until the principal is paid or merged into a judgment.
So could you write an indenture that said, I'll pay you all the principal back in 3 years, and I'll pay you the interest back 20 years after that?
Sure, you could write that.
And why isn't this that?
Because it doesn't say that. It says, right, because in your hypothetical, it says, I'll pay you the principal in 3 years, I think you said. So if you didn't pay the principal in 3 years, then they would have this, whatever the statute of limitations or contractual prescription period, to then claim the principal. And then I've promised in 20 years, I'll pay you the interest. So in 20 years, if I haven't done that, then we look there. Here it says, you have the right to get that interest along the schedule, or if I default on principal. And so the clock starts to run. His rule, of course, is unworkable.
And in this hypothetical that you just went through, the interest is accruing even after the 3 years when you had promised to pay the principal, or after the prescriptive period or the statute of limitations had expired?
Well, I guess it depends on how the hypothetical contract is written, but if you had a contract that said, I'll pay you principal in 3 years, and the principal will accrue interest until paid, then you would sue, and then you could get your judgment, and it would include the interest, but then you'd have this separate right, again, accepting how it's written in the hypothetical, to go after the
So
interest.
there's a certainty there that
There is a
addresses the public policy issues that we know it's 20 years out.
Yes, exactly. And here you have no measuring life, right? His standard is 4 years, he used the term floating interest. The 2060 problem, I think we used the year 2050 in our brief, but that's the exact problem. Merger doesn't solve that, because merger talks about successive actions. And I would like to speak about merger briefly, because I think merger confirms, in another way, why the theory from the plaintiff here is wrong. Because merger says, okay, if you bring on a cause, an action, and you get a judgment, that bars a second action on the same cause. He says, well, that would solve the problem. But once you agree that a suit for interest is the same cause as another suit for interest, then why isn't the same cause as the day after September 4th, 2007, post-maturity, when you could sue for interest and the cause accrued? So if you accept the sort of merger analysis, that's another reason why this claim is barred 4 years after. I'd also like to make the point that this really...
So what was the point of the phrase that interest is owed until the principal is paid, or however it's phrased?
As NML says, that sets the stage for when you bring the suit on principal, then the...
Well, this agreement predates NML.
Correct. But I would say that it basically means that interest continues to accrue at the contract rate until merged into the judgment, and then NML adds the fact that since it's a contractual obligation, it draws the statutory 9% interest under CPLR 5001. So that's all it does. But I think for his purposes, and again, as Judge Garcia noted, that was all a timely case in NML.
But you're saying, so the language is not that it's tying the interest to when the principal is paid, I may have misunderstood you, to the amount of interest? Is that what you're arguing?
No, it's making very
CPLR,
clear.
I'm sorry.
So the CPLR is saying, since it's a contractual obligation to pay the interest of the contract rate, you can get, on top of that contractual interest, a 9%.
Interest on the interest, yeah.
Correct.
Yeah,
correct.
Thank you, counsel.
The other point I would just say, this really risks...
You may have another moment, sir.
Inundating New York courts with claims, these kind of floating claims on long past due principal claims, a particular problem for sovereign issuers. Sovereign issuers cannot go bankrupt, which means they can't stop the running of interest. And so we cite in our brief, this is just not a fanciful concern. The Second Circuit Schmidt case involved an attempt to litigate in my lifetime Polish debt from the 1930s. We cite the claim involving Chinese bearer bonds that were being dealt with in the federal court. So it really would be an inundation, potential inundation for the court system of these kind of long time-barred claims. Thank you, Your Honors.
Counsel?
Thank you, Your Honors. I'd like to make 3 points. The first point is the first point I made in my opening, is that NML Capital makes it clear that the plain terms of a party's agreement control, particularly when it's a sophisticated financial document and the bond issuer was represented by sophisticated counsel. Mendoza could have written this contract to achieve precisely the rule that they advocate here. They could have said that the prescription period runs for 4 years after the accrual of each claim, and all claims are prescribed 4 years after maturity. That's not what the indenture says. Nothing in 4.6 says that either. All that 4.6 says is that upon maturity, you can bring claims. That doesn't mean that unaccrued post-maturity interest claims are somehow extinguished at that point. The other point that I'd make is that my friend relies on Vigilant a number of times. In Vigilant, this court actually said that when you have separate installment payments for interest, they accrue separately. That's precisely the rule that we're arguing for here. The other point that I'd make is that their argument about 4.6 is really just a subspecies of the argument this court rejected in NML Capital, where Argentina argued that maturity somehow extinguished rights to interest payments after maturity. And then the last point that I would make is that the court does not need to find in the affirmative on question 2 to find in the affirmative on question 1. We think that merger and latches would supply a limiting principle. If they don't, then that's only because of the language that Mendoza wrote in its own indenture. And we can't forget that the reason why we're here is that they voluntarily stopped satisfying their obligations. At any point, they could have eliminated this situation by paying principal, or if we prevail in this case goes away, and Mr. Ajdler is the holder of the vast majority of remaining beneficial interests. Thank you, Your Honors.
Thank you, counsel.